हेलो एवरीवन। इस वीडियो में हम पार्टनरशिप एक्ट के कुछ प्रोविजंस को समझने का प्रयास करेंगे। सबसे पहले डेफिनेशन की ओर जाएंगे। अक्सर ये सवाल किया जाता है कि पार्टनरशिप फर्म जो है वो कोई ज्यूरिस्टिक पर्सन है, लीगल एंटिटी है या नहीं है। तो हम एक बार डेफिनेशन को देखते हैं। सेक्शन 4 में दी गई है, पार्टनरशिप इज द रिलेशन बिटवीन पर्सन्स who have agreed to share the profits of a business carried on by all or any of them acting for all। आगे जो प्रोविजन है वो रेलेवेंट है। Persons who have entered into partnership with one another are called individually partners and collectively a firm। So it is clear that in the eyes of law, a firm is merely a collective name of individuals who have entered into partnership। It implies a suit against a firm merely means a suit against all the partners of the firm। एक बेसिक क्वेश्चन ये समझना चाहिए हमें कि पार्टनर, who can be a partner? Though under the act no explicit qualifications have been laid down, but when we go through the provisions, we come across certain provisions which give some idea of a person who can be inducted as a partner, who can work as a partner। In this regard, section 31 is important, which relates to introduction of a partner। Subsection 1 of this section 31, it lays down that subject to contract between the partners and to the provisions of section 30, so these two conditions are there. If there is an agreement between the partners and the provisions of section 30 which relate to admission of a minor to the profits, no person shall be introduced as a partner into a firm without the consent of all the existing partners। So here again we don't find any qualification or eligibility condition for a person to be introduced as a partner। It merely lays down that a person can be introduced or no person shall be introduced without the consent of the existing partners। But then because it is subject to the contract between the partners, they may lay down that a person who has some experience in the field of the business being carried on by the firm, he may be introduced as a partner। So this type of conditions can be there। So a person cannot be introduced without the consent of the existing partners। That means the consent of all the partners is necessary if some person is to be inducted as a partner in the firm। But then what section 30 says? Subsection 1 of this section, the main section relates to minors admitted to the benefits of partnership। A person who is a minor according to the law to which he is subjected may not be a partner in the firm। It also provides a negative condition that a minor may not be a partner in the firm। It means he cannot be a partner in the firm, but with the consent of all the partners for the time being, for the time means the existing partners, he may be admitted to the benefits of partnership। So who can be a partner? No clear idea। It depends upon the contract between the partners, but minor cannot be a partner। However, he can be admitted to the benefits of the partnership, that can be there। So first thing we find that a minor, he cannot be a partner। So who can be a partner? A partner should be a major person as per the law to which he is subjected। Then when we move further, we find section 34 which relates to insolvency of a partner, where a partner in a firm is adjudicated and insolvent, he ceases to be partner on the date on which the order of adjudication is made। Insolvency is declared by the courts, we all know, So if a partner is declared insolvent by the court, he ceases to be a partner on the date of the order itself. So henceforth he will not be considered as partner in the firm. He ceases to be a partner. So these two things come to fore, that a minor and an insolvent person, they cannot be partners. Because if an insolvent person is inducted, he ceases to be partner on that date, on the date of the order itself, and a minor, he is barred from becoming the partner. However, admission to the benefits of partnership is available to him. As we notice that in section 34, the last phrase says whether or not the firm is thereby dissolved. So when we go to the provisions of section 42 as regards the dissolution of the firm on happening of certain contingencies, so insolvency of a partner in the firm can lead to dissolution of the firm, though it is subject to the contract between the parties again as provided under section 42. Section 42, it is important from the examination point of view. It relates to dissolution on happening of certain contingencies. I go through the section first and then we'll explain. Subject to contract between the parties, a firm is dissolved. There are 4 contingencies which have been given in this section. The first is, if constituted for a fixed period by the expiry of that term. So if a firm is constituted for a fixed period, say 5 years, 10 years, 15 years, then at the expiry of that period, 5 year, 10 year, whatever it may be, the firm stands dissolved with the expiry of that term. Here, I will bring you to the provisions of section 7, which provide partnership at will. So means if it is not partnership at will and duration of the partnership is there, then the partnership dissolves with the expiry of the term. Then we have to understand what is the meaning of partnership at will. Section 7, and I mentioned it at this stage that normally a question is asked in the examination from this section about the partnership at will. It lays down 2 conditions. The section says partnership at will where no provision is made by contract between the partners for the duration of their partnership, 1, or for the determination of their partnership. The partnership is partnership at will. No duration is given and no conditions, no circumstances as to determination, under what circumstances the partnership will determine, it will end. If these are not given, mentioned in the contract between the partners, then it is the partnership at will. But here we find that the first condition regarding the dissolution of the firm is as regards the firms which are not partnership at will, where duration is given. Of course, second part relating to determination is missing there, but only duration is given. With the expiry of that, it goes. Then next, one thing more, that these provisions regarding duration or the circumstances of determination of the partnership need not be expressed. These can be implied also from the terms of the contract, of the agreement. The implication can be drawn as regards the determination of the partnership. 42B, if constituted to carry out one or more adventures or undertakings by the completion thereof. Provision is very simple. If partnership is constituted to complete one or more adventures or undertakings, then with the completion of that, the partnership stands dissolved. And then the death of a partner, it also leads to dissolution. But in the beginning, we have seen that all these clauses are subject to the contract between the partners. Now, the relevant clause we come across, by the adjudication of a partner as an insolvent. So if there is no agreement to the contrary, then by the adjudication of a partner as an insolvent, the firm will stand dissolved, but it is subject to the contract between partners. They may decide that with the declaration of one of the partners or even more, as insolvent, the firm will not be dissolved and it will continue with the business. So first ineligible person I would say is minor, and the next one is insolvent. They cannot be partner in the partnership firm. And at this stage I would say that provisions regarding the minor in subsection 5 of section 30 are important from examination point of view, which too I discuss in this video. Subsection 5 reads, at any time within 6 months of his attaining majority or of his obtaining knowledge that he had been admitted to the benefits of partnership, whichever date is later, such person may give public notice. The minor, such person means the minor who was admitted to the benefits of the partnership within 6 months of his attaining majority or within 6 months of the date he attains the knowledge that he was admitted to such benefit. I would say that when in the present day circumstances, the second part is not that much relevant, because today if a minor is admitted to the benefits of a partnership, it is but natural that he will receive the benefits in his bank accounts, etc. So he will have the knowledge. But the law goes like this, that within 6 months of his attaining the majority or having the knowledge that he was admitted to the benefits of partnership, he has to elect. What? He has to elect. Such person may give public notice that he has elected to become, or that he has elected not to become a partner in the firm. So he has to make the choice whether to become a partner or not to become a partner, and for that he has to give a public notice. This public notice is very important. In the Partnership Act we will find that at a number of places the public notice is to be given by the partners, and such notice shall determine his position as regards the firm. Naturally the notice becomes important, provided, this is important, provided that if he fails to give such notice, he shall become a partner in that firm on the expiry of the said 6 months. So if he fails to give the notice, then there is no way out that he chooses to become not to become partner. He is, by the implication of these provisions, he becomes the partner in the firm, and then his liabilities and other things, they go as per the legal provisions, and he become a regular partner in the firm. So we try to find out who can be a partner. Any person except minor and an insolvent. In this regard, as far as this section related to minor is concerned, section 30 and other sections following it, I would say you must mug up or just rot is not the appropriate word, but you should keep in your memory the 4 sections and their headings regarding which question can be asked in the examination. First is section 30, which relates to minors admitted to the benefits of partnership. Then section 31, introduction of a partner. Then section 32, retirement of a partner. And then section 33, expulsion of a partner. So there can be a straightaway question. The sections are mentioned there, and in front the headings are given, and you are asked to find out the correctly matched pairs. Similarly, the sections which relate to dissolution of the firm, these start from section 40 and run up to 44 with different headings. So you must make a chart of these sections and memorize the sections as well as the headings of these sections, so that if any question is asked, you are able to find the correctly matched pairs. Section 40, its heading is dissolution by agreement. Section 41, compulsory dissolution. And section 42, dissolution on the happening of certain contingencies, which I explained to you, which talked of insolvent persons also. 43, section dissolution by notice of partnership at will. And the last is dissolution by the court. So section 40 to 44 with their headings, you must memorize and keep them in your memory, so that if a question is asked, you are able to answer that. That's all in this video. Thank you very much.